This is Jeff Kravitz, and I am joined by Bob Cohen today for the ADR section. And by brief introduction, Bob and I have been doing these meetings for about a year and a half now. And we sat down and we thought it would be fun to have a discussion on what mediators don't tell you. In other words, what's behind the curtain that you may not see as a litigant, or if you are a mediator, what is it that's rolling around in your head as the parties are knocking their brains out trying to persuade you of their position? As I mentioned, I'm joined by my colleague and friend Bob Cohen. He is a mediator with ARC, the Alternative Resource Centers, and with MCLA, the Mediation Center of Los Angeles. He received advanced training from the late Jeff Kravitz and from Forrest Woody Moslin. Before mediating, he was a litigator with Cohen, Slimpert, and Ford, a boutique real estate and general litigation firm. Bob, to you.
Okay, and I'd like to introduce my good friend and colleague, Jeffrey Kravitz. Jeffrey and I went to UCLA. I'm going to go a little off script because that's kind of my nature. Jeffrey and I both went to UCLA exactly at the same time. He was a philosophy major, trying to learn as much as he could. I was trying to get the best grades I could and was into social kind of student body things and working in the media. And I took 5 years to graduate, and I ended up at Loyola a year after him. But Jeff Kravitz is also a mediator with ARC, the Alternative Resolution Center, and he's an arbitrator with the AAA. And he has a career as a very successful litigator and trial attorney. He started off at the AG's office, I believe, and he cut his teeth there and got his head beaten a few times. And through that process, he became a very capable trial lawyer. He was with some different major law firms. As a trial lawyer, he has extensive experience in the entertainment industry and in intellectual property and insurance disputes. And he ended up, before moving into mediation full-time, as a partner, and I believe he was at least a managing partner for a few years with Fox Rothschild. And he and I have been working together. We are in sync pretty much. We see the world the same way, but from different perspectives. And I think that I just have to say it's a real pleasure to work with him. And I think in today's world of chaos, that's why we have much to talk about today as to how to come up with secret solutions that we don't share with other people that we're now going to try to share to get these cases settled, because people are angrier than ever and the chaos is greater than ever. And I think we all need, a secret weapon, and it may be not so aggressive a weapon. It may be a nice weapon, but we need to think deeply as to how we can get things done in a chaotic world. So, Jeff, why don't you start off? This was your idea.
That sounds fine. I'm going to go off script a little bit as well, which is, you mentioned the profound anger that's out there. And as a mediator, I do sense it. I have any number of tools I try to break the ice. But I'll tell you one of them that is a hard stop no, which is I'm not there to talk politics with anybody. One of the best mediators that I know, years ago, my client was from Florida, and the mediator trying to break the ice said, "Oh, my assumption is that you're supporting Senator Rubio for President of the United States." And my client said, no, he was supporting the guy who eventually became our president. And we were off sync for a good half hour because the door had been opened to that third rail, which is politics. Bob, does that discussion ever crop up when you're doing mediation, or is that?
No, I haven't had that happen yet, but you can read people's facial expressions and eyes, and you can tell when they think you're coming from a different universe and they're uptight. And I think, one point that you've made, I think, in our discussions is you've got to let the parties speak, because if they don't get their feelings out, they're ultimately not going to be an active participant in the mediation process, and their lawyers will really take command. And I think that when I started off mediating, and I started mediating in the 90s, and I didn't know what I was doing. And then I started again after I did the Pepperdine course with Jeff Kravitz, and I kind of knew what I was doing. But at that point, I was kind of telling people what was going on and what the law was and what they should do. I do that very little now. I try to let them talk and express their feelings, and then try to ask questions that kind of leads them in the direction that I think they should go, or with regards to what's missing. So I think that letting the parties talk and showing empathy, and people can read you from a monitor. They really can if they're astute. And you've got to get to the point where you're empathetic and they feel you care about them. And I think that helps a lot to diffuse anger and anxiety. That's my take on it.
Well, and I think that's important. During the course of my litigation career, interviewing thousands of witnesses, I used to initially start out with a series of questions and notes and try to get their story out sequentially to make sure that it made sense. But what I found was that until you get the emotional component out there, you're really going nowhere. And my most, quote, sophisticated, end quote, question became my go-to question, was simply to say, what happened? And at that point, the floodgates would open up, regardless of the type of case it was. It could be a wrongful death case. It could be a complex intellectual property matter. It didn't matter, because people are invested in their litigation. And as a mediator, simply asking the question to the client, not to the lawyer, what happened, produces all sorts of interesting responses. But
Right. No,
yeah,
I agree with you. So we have a fairly large audience today, and I think they were drawn here because they want to find out about our secrets. So I'm going to talk about one of my secrets that I don't really ever tell the attorneys or parties, and that is when I have really long briefs that come in at the last second, I do AI summaries. I do them and I look at them, and that gives me a quick Cliff Note overview of what the case is about. And then I spend my time kind of skimming slowly the briefs and confirming that the Cliff Notes are correct. And then it really sinks into my head, and it saves me just a tremendous amount of time. I find that AI is getting better and better. I've done this probably about 30 times so far on bigger briefs, and only one had a mistake where a case citation just came out of left field. So you do have to double check these things. And of course, I don't tell the parties that I've done this, but what I do is go over the case in a bullet point type of manner at the beginning, and that makes them feel comfortable. Like I've read their brief, which I have. I didn't take an hour and a half to go through it, which I might have to do if I didn't have the summary. Maybe I spent half an hour, but I've read the brief, and that gives them a comfort level, and they're relaxed, and they have a lot more respect for me. And in today's hectic world, getting briefs at the last second that are lengthy, maybe 20 pages with 100 pages of exhibits from 3 different parties, 3 different attorneys, it becomes difficult. And mediations that I do for MCLA, I love MCLA. It's wonderful. The founders are absolutely brilliant guys. And it pays, but not enough for me to stop my work from the day before to spend 4 or 5 hours prepping for the mediation. So in that situation, it really helps me, and it increases my my ability to guide them to a resolution and to make them feel comfortable. So I think AI, if you understand its weaknesses, can be very helpful. And there's a new AI program called from Google called Notebook LM that is different from ChatGPT, that confines itself to just the four corners of your document. ChatGPT goes through the world and can throw in crazy stuff. Notebook LM, and I've only used that once, my brother who's a screenwriter uses it, sticks within the four corners of the document, and that's great. So from a security and ethical point of view, I think that that may be the way to go. But the point is, there's technology out there and we should utilize it to do a better job and save time.
Well, I'm not a tech guy, but I do like to hear from the clients. And let me give you a couple of examples as to that which I heard from the clients, which I wouldn't have heard from the briefs or from AI. One was in the IP world, and one was a personal injury lawsuit. The commercial case was one that involved two merchants in the jewelry district of Los Angeles, and they were diamond merchants. One of them was of Chinese extraction. One was from one of the Russian republics. And I asked what happened, and they started coming at each other in a combination of English and their chosen language. And I said, no, let's sort this out. And I actually brought in two translators. The issue was about a diamond. And I said, I'm not mediating unless I see the diamond. It was a whopper. And one of the merchants thought he had made a sale, and the other guy thought that it was on consignment. And sorting it out with the translators, not the lawyers, but the translators, we were able to reach resolution where they walked out hugging each other. And believe me, that doesn't happen a lot in mediation. So that's the one from the commercial world. The one from a personal injury lawsuit was involving a state mental facility where one of the patients had died. And part of what we do as mediators is test the theses of each side. And I went in wonkishly with the mother of the woman of the guy who had died, and I said, look, I'm sure you loved your son, but he wasn't employed, he wasn't housed, and she looked at me, and this was a woman who was on public assistance, and she said, Mr. Kravitz, do you have children? And I said, yes. And she said, well, then hopefully you have learned that you don't have them for them to be commercial successes. You have them to love and to cherish them. And at that point, we worked our way towards resolution. Trust me, that was nothing that appeared in the brief of the gentleman who was representing them. And by the way, he was a really good lawyer, but he didn't have that touch that the client brought to the situation.
Interesting. Now we have a couple of questions already. One from Judge Bacigalupo, and hello, Judge. And he wants to know, how do you deal with an attorney who doesn't want their clients to talk? And that's a very significant question, and that is a problem occasionally. How do you deal with that?
Very directly. I put on my big boy pants and I say, look, part of the reason that you go to mediation is so that the clients can understand what's going on, what the process is, hopefully resolve it. But if they don't resolve it, at least they're going to understand what the process is and where their case lies coming out here. And then I look at him or her very directly and I say, chalk this one up to my ignorance. I am not going to understand your case unless I hear from your client. And then I pause and I say, now I am sure that you have absolute confidence in your client, which they don't necessarily. And I need to hear what they have to say if we're going to resolve the situation. Bob, how about you?
Well, in that situation, as I've become a little bit more sophisticated in the last 4.5 years, I will go to a separate breakout room with the attorney and talk to him or her and say, we really need to get your client to open up and feel like he or she has been heard. And most of the time that works. A few times, it usually isn't a problem. And when it is, I would say that works 90% of the time. And there's always one or two attorneys that are just very much in your face, and they're the boss, and they're not going to let the client deal with the mediator directly, even if they're there in the room. Now, another question that was raised, and it's a very good question, it's made me think about this. And I'm not perfect. I make mistakes all the time, every day. Yeah, I just admit it, maybe more than some. Regarding the use of AI, the question is from Heather Atkinson. It's owned by Google. Are you concerned with privacy or first getting the client or attorney permission before putting their information to AI? Now, I think that's a good question, but my understanding is, and that's made me think, and that I don't think applies to Notebook LM the way I understand it, but I will check that out. But I think it does apply to ChatGPT. And based on that, I think I probably should stop using ChatGPT. I don't think that's going to be a problem. I haven't done it, that many times, although I've been doing it more regularly in the last half year. And I think that's a very good point. Another question is there a catharsis value to a plaintiff being able to be heard for the first time? And I would say, just before you comment, absolutely. This is oftentimes clients and parties are timid, or their feelings and thoughts are suppressed by the lawyer who doesn't want to get into their feelings and thoughts, yet they're the ultimate decision maker. And if you can get into that zone, that's very helpful. I have an example, maybe I'll discuss later, of where the lawyer was in total control and wouldn't let the client talk, and there was nothing I could do about it, and it was a busted mediation. Jeff, what do you think? Is catharsis good, or does that just create more chaos and anger?
I think it's essential. I don't think it's good. I think it's essential. And it is from a couple of respects. I mean, I gave you two examples that turned out quite well. But the more common situation is clients who are, I don't want to say overly invested, but let's just say super invested in their case, to the exclusion of everything else that life has to offer. And I try to hear the client, but as diplomatically as I can, I then try to find out what else is going on in their lives. Okay, for example, if I'm sensing the situation correctly, I'll say, gee, my son and his whole brood and family are about to show up at my house. And while I'm thrilled, I'm a little bit concerned. How would you handle the situation? And at that point, you've taken them out of the mode of 100% being invested in their case and making them realize that there's a whole life out there to be enjoyed. And I try to steer them away from the sense that they're going to destroy the other side, and to the sense that if they resolve the situation, they will be able to, once again, 100% be able to enjoy those grandkids, because they're not going to be spending their time on the lawsuit. They're going to be on the playground with those little rugrats.
No, I agree with you, and completely. And I have a case situation that I might share later, if time permits, where that became the whole focus of the mediation for the grandparents that were fighting over past child support from a divorce from 30 years before, and who owed who, and allowing the father, the grandfather, to suddenly see the grandchildren again. So there was money involved in grandchildren, and we worked out a very interesting solution that satisfied everybody and stopped the crazy litigation. Now, Ben Williams mentions that Notebook LLM can be open and scour the internet or closed to the files uploaded, and you have to choose that option, he believes. And I think he's right, and I think that's a really good point. And also, we make mistakes, and maybe I've made a mistake. And you know what? When I make a mistake in a mediation, I apologize. And should mediators apologize? And my position is yes. If the clients feel that you've insulted them or haven't listened to them or interrupted them, I think an apology is the good thing to do. And I have a very funny case example along those lines. I was doing an HOA case, and those are some of the toughest. And I know a lot about HOAs because I've lived in them, different ones, the last 15 years. And there's nothing easy about common ownership in terms of disputes. So there was a dispute, and the number one HOA law firm was representing the board, charging a lot of money, probably more than my hourly fee. And there were three board members there, and they were very uptight and very angry about the way that this owner was literally driving them crazy. And the owner did not want to come to a resolution. And I kept going back and forth and doing my very best to make it happen. And out of total frustration, after about 2 hours, two of the board members said to me, "You're not working hard enough for us. We need to get this case settled. You need to do better." And they went on, and they excoriated me. And my response was unfortunate. I said, because I have this strange sense of humor, I said, "What do you want me to do? Hit her on the head with a stick?" And at that point, the attorney, who was very full of herself with the big HOA firm statewide, said, "That is absolutely inappropriate. You've insulted my clients. You've insulted me. I'm thinking of terminating this mediation right now." Now, I could have said, well, go ahead and do it or whatever. But I said, no, I want to make this mediation work. So I said, "I am so sorry. That was absolutely inappropriate. I apologize. And you're right." And I, genuflected and all that stuff for about a minute. Probably did it a little bit too much. But the point is, we got over that and then went on with the mediation. We did get a resolution finally after about 5 hours. So, we make mistakes, and I think there's nothing wrong with an apology. And Peter Robinson over at Pepperdine is like the expert on apologies and mediation. And I think it works for everybody, for the mediators and the parties and even the lawyers, although not everyone is willing to do that. But I think it has a lot of power.
And you got to be able to read the room. I mean, I won't mention who it was, but one of the really giants of the ADR field was known for laying F-bombs out. And two cases that I had before him, the first involved two producers in the entertainment world, and they were frenemies. They did everything together, including suing each other. And the mediator walks in, takes a look at the two of them, and says, "Do you think my people downtown are going to give a blankety blank about you two blankety blank producers?" Well, that was needed because these guys had egos the size of a football field, and we ended up resolving the situation. The guy was a powerhouse. He was wonderful. Take a second mediation to him. This involved a real estate partnership. My clients were 30-somethings, and the guy on the other side was 80. And the mediator comes in, lays out a couple of F-bombs, and at that point, the 80-something basically said, "I'm out of here. I'm not here to be insulted like that."
Right.
The
That's right.
mediator took a deep breath and said, "You're right. I tend to do that. It's not my most attractive quality. I'm really sorry. I flat out apologize to you." And at that point, we ultimately resolved the situation.
I've never done that as a mediator, but as a litigator, I did once as a mediation advocate with my clients. And it wasn't really directed toward them per se, but I did use the word about ignorance and not understanding. And what I didn't realize is these people were deeply religious, um, um, and evangelical, and they took that as a total insult. And about a week later, I was subbed out of the case.
Whoa.
And tell me who's perfect. I don't know, but I think you need to really be careful when you're a mediator, because you are being watched by all sides, and you have to keep that in mind. And Jeff, I have a question for you. What do you think about likability? Is it significant that the parties and the attorneys like the mediator, or is that, irrelevant? What do you think about that?
Different folks, different strokes. I don't have to be their friend. I don't have to be the anthropomorphic God sitting on high. I try to read the room and determine, in this particular case, uh, what's going to work. I mean, Turing, we've got a question which kind of segues into this, which is, what are the key differences between the role of mediator and arbitrator? And I like to say that mediation is uh, 1/3 law, 1/3 psychology, and 1/3 magic. But I am a persuader. I'm not a decider. When I am an arbitrator, I am the judge. And particularly when I am an arbitrator, I do not feel any need to be their best buddy. And I think that detracts from the dignity of that which we are doing. I must say, I have never had a mediation where I walked out and became friends with either the lawyers or the contestants. That's not what we're there for.
Right, I agree with that. And yet, on the mediation side, they don't have to think you're their best friend. But I think if you can get a rapport with them where they are comfortable with you, and to a certain extent, even like you, I think that's very helpful. And Cialdini has his 7 principles of persuasion, which are very powerful and very interesting. And one of the ones is likability, because if you like someone, you will do things for them that you might not do for someone else. I used to think when I was in high school that it would be nice to be, school president or class president and all those things. And I did some stuff, but I was not class president, not school president. And I analyzed who was getting elected over and over again. And I said, there are people that everybody just likes. They're just comfortable with that person. They're generally bright, not the brightest necessarily, but they get along with everybody. Everybody feels comfortable with them, and then they want them to be the school president. And I've seen that with even mediators. I know mediators, one of whom was a very successful judge, and one of whom was a very successful big law litigator, primarily for the defense, handling really big national cases. And I noticed that they were just incredibly likable and at ease when they were mediating. And we talked about it. And one of them I was even involved with writing an article or two. And I said to them, just off the top of my head, I said, what high school did you go to? Oh, so-and-so. One was in Hawaii, one was in the Valley. I said, you were school president, weren't you? And they said, yes, I was. And then one of them, I said, where'd you go to college? And University of Hawaii. I said, did you happen to be school president? He said, yes, I was.
Yeah.
And I think that's, I'm not 100% likable. Some people really get irritated by my candor and whatever, my personality. But I think that the more you can go in that direction, if you can work on that, it's helpful. It's very helpful to get the people to calm down, use their rational, logical brain, and try to find a solution. And people want to please those that they like. So, Jeff, what about dressing and appearance and things like that? Is that significant or not? You and I are both wearing ties. I don't wear a tie during the week. I used to, I grew up in the I was a lawyer in the mid 70s, and it was wingtip shoes and white shirts and ties and all that. But that's certainly not the way it is now. Is that important or is that irrelevant?
Well, first of all, we're living in an era where we have a U.S. senator who shows up on the Senate floor in a pair of shorts.
Right.
So things have clearly changed. I came from a given perspective. My father had a dry cleaning store. Father-in-law sold men's suits. And so initially, when I started out in mediation, I was in the quote, dress for success mode in terms of the parties. And I've modified that. I now tell people to dress for comfort. And the reason is litigation is stressful enough as it is. I don't need the litigants uh, to be dressed a certain way in order to work with them. I did an arbitration about a week ago involving a tech guy, and he pleased me. He wore a black t-shirt the first day, and he wore a white t-shirt the second day. That was fine because he was comfortable with the presentation, and I think that's probably more important than the dress for success rule. I think that's a shibboleth that has outlived its usefulness. Um, Ron, we got a couple of questions, one from Ron Reithstein. Maybe you could field it.
Let's see. Got to move my cursor down. Why don't you say what it is? Because I can't find it on my
Okay, it says, do you use
Q&A.
penalty time, leaving parties alone in their separate room, that is, conference rooms in advance, or to redirect the process?
I'm sorry, I missed the first part. When
Okay.
they're in separate
Do,
rooms.
do you use penalty time, leaving parties alone in their separate box?
Okay, I got it. I got it. No, I never do that. In fact, I try to do the reverse. I try to impress upon them that I'm here to work just as hard as I want them to work. And I constantly communicate with clients and say it's going to be, another 10 minutes, another 5 minutes. And I don't let clients stew over things. You see, penalty, I think maybe it's the wrong word to use. Do I use time out or time for them to consider stuff? Yes, but I don't punish them for being uncooperative. I try to talk it through with them. And, again, it's about a 50-50 situation. But I try to be, in a kind way, very engaged with them, which some people might call in their face. But I don't think that's what it is, because if I come with an empathetic, sympathetic approach, and they can tell that, and if they think that I care more about them than my mediation fee, which oftentimes is, I think parties are not sure about that, I try to make that clear. I think it helps. So the idea of penalty time for them to straighten out, no. However, again, I impress upon them that if we go over a little bit, 15, 20 minutes, 30 minutes, I'm not going to bill them for it. And I've had mediations that have been continued many times where I turn the clock back a half hour, 45 minutes, so that they have more time. And I'll tell you something, maybe I'm losing a few bucks, but they then have buy-in because they see that I have skin in the game and I care about them. I think the more the parties recognize that you care about them in mediation, the more likely it will result in a good result. Now, there are some parties and attorneys, more particularly, that just don't care. They don't care. I call them fullbacks. They just run up the middle, and that's it. So you can be as nice as you want to be to them and do everything in the world, and they just don't give a damn. But for most people, they respond to it, and that includes attorneys. So I don't know if I've answered Ron's question, but Ron, thank you. And I have a question for you.
I'm going to disagree with you on that one.
Okay.
There are times where a party will get so worked up, they may even be hyperventilating. And I don't want to use the expression penalty box because I don't look at it that way. I prefer the expression that they use in child rearing, and believe me, I'm not infantilizing anybody, but the expression is a timeout.
Right. Well, that's what I
And
said. That's what I said earlier. So we're not in total disagreement.
right, right. Uh, okay.
Well,
Now,
here's another question for you. What do you do when there is disparity between the level of lawyering, or when there's a pro per on one side and a lawyer on the other side in mediation? Now, this is not arbitration. What do you do? And I know that the very successful and esteemed Jeff Kitchhaven makes it very clear that his position is hands off. It's not my job to help anybody. What do you do in situations like that? Because there's another school of thought too, which I'm more likely to subscribe to.
well, this is one that mediators talk about over a couple of drinks because it's not easy. And the reason isn't easy is because, and I'm not being tongue in cheek, any number of lawyers went into lawyering because they wanted to do justice in one fashion or another. And you can be looking at a situation where there is that uh, disparity and there is an urge to try to put your finger on the scales of justice. And it's a problem. And the reason it's a problem is because if the case goes to trial, uh, that disparity may or may not be noticeable. Okay. Which may mean the skills of one lawyer may transcend the skills of another, but that doesn't mean the jury is going to side with a better lawyer. There have
Right.
been any number of wonderful lawyers who have lost cases to people with half their talent because either the facts don't merit that result or the jury went kind of crazy. And I must say that I err on the side of keeping hands off because I don't know what the dynamic is going to be if it goes to trial. So I just let it play out. The more difficult situation is the pro per. And the reason is most pro pers I have found come in with a large degree of cynicism about the process. On the one hand, they divide into two clans, those who are incredibly cynical and those who are incredibly naive. And what I do think my role is to explain as best I can how the process works, and not only how it works, but how it works in their particular case. But what I will not do is to make myself the lawyer for one side or the other.
Interesting. I want to go back to Ron's question because I've thought a little bit more about that, and I don't think my answer was really that great. But here's what I was trying to explain. And Ron, of course, is a very competent divorce lawyer. And I can't even imagine when he's doing a divorce mediation how angry and out of control people get. I mean, I can hypothesize about it, but I've never really experienced it other than maybe a couple of situations in my life. So I think the way you phrase your action or what you want them to do is very significant. And I think that people need empathy, especially in divorces. They need to feel validated. You're having an awful experience. This is so bad, but why don't we let you go back into your room for a while and we'll come back? Instead of saying jokingly, which I certainly would have done years ago, it's time for you to be in the penalty box and we'll come back when things calm down. Now, the difference between those two statements, I think, with the right person can be night and day. And I think you only learn how to communicate that way by having what I call flight time, being a mediator and actually making the little mistakes and then seeing how you correct yourself. I think that's what we all do. But that's my take on the penalty box versus an empathetic response and saying, we'll come back, go get some Kleenex.
That leads us into one of the questions that we're getting from the assembled. And the question reads, in employment mediation, how do you move the case forward when documented facts and all witnesses refute workers' claims, yet the employee continues to demand hundreds of thousands or more? That's just a great question. And part of how I approach it is to come in with an understanding that people sue largely for two reasons. The first is about the Benjamins, but the other is about dignity. And particularly in employment situations, uh, oftentimes the dignity question transcends seeking a lot of money. And what I try to do is to say to this imaginary employee, not you've got a terrible case, but something more along the lines of, you got a tough road to hoe. Okay. And uh, pause, see if I get a reaction, and say, look, I really understand that you feel terrible about this situation because you feel that your dignity has been assaulted. Okay. And sometimes I'm met with a just a wall of anger, but sometimes there are situations where that employee will then have a recognition that the task is maybe to get him some dollars, but also that each side emerges with a sense of dignity about the situation.
Yeah, no, I agree with that. And I've had the situation not with parties, but with lawyers in particular where there's statutory legal fees, and they want just a tremendous amount of lawyers' fees as a part of the settlement. And I had one case where the case had not yet been filed, but there was a statutory requirement for a pre-filing mediation, again, in an HOA situation. And the attorney who chose me, because I've written about HOA mediations and disputes, came in with a request. Part of his damage package of $500,000 or more was I think $150,000 or $200,000 of legal fees. Yet there had not yet been a lawsuit filed, and it was over typical stuff, water damage and all sorts of things to the unit because of alleged negligence on the part of the HOA, which may have been true. But instead of handling it in a kind and sympathetic way and validating, even though I felt his claim was completely preposterous, I told him he was wrong. He wasn't going to get it. And I also did another no-no. I said, you're a young lawyer, and I know you feel very passionate about this. I'm sure there's many points that you have that are correct. But the other attorney has been doing this for 35 years. That's all he does is defend HOA claims. And I don't think you're ever going to get anywhere near that, even above the low to mid 5 figures. And he was so upset. He was incensed. And I don't usually get complaints, but that was one of the few that I did receive because he felt that I was belittling him. And that becomes a difficult issue. Do you buy into their insanity or their ridiculous posturing and make them feel better when you know that it's going to be a busted mediation? Or do you tell them straight that they're wrong and that they're being foolish? And I think as a beginning mediator, I was tempted to do the latter. And as a more experienced mediator now, I go with the former, because I think the ride, the process, is almost as important as the destination. And it's that way for two reasons. One, you can get them to calm down and hear and think logically about what's happening. And two, they don't have a sour taste in their mouth when the mediation is done, and they feel like they've been heard, and maybe the case didn't settle, but at least they're making some progress. Had I had the ability to do it over again, do a mulligan, I would get the attorneys together. And I would say, gee, X, you want 150,000 or 200,000. There's been no filing. Y, you don't believe he's entitled to anything other than maybe a couple $1,000. Why don't you guys talk about it? And then I would let them do it that way. But by taking charge and telling them what I thought was the result, I became the enemy, and it made them feel like it was a waste of time. So that's something I learned.
It can happen. We do have an interesting question, which is, do you put people in separate rooms? Do you put everybody together? And I have kind of a unique perspective on that, which is there's a statewide organization called California Lawyers for the Arts. And unlike traditional mediation, they put everybody together in one room. And I got to tell you, Bob, sometimes it's like a food fight. And
Yeah.
it can be um, difficult. And I think it works in the arts because, forgive me, my experience dealing with the entertainment industry is that people have pretty thick skins and they can yell and scream and get it all out and still come to resolution on matters. Not to say I haven't had busted mediations when that technique is used, but that's the preferred modality for California Lawyers for the Arts. Short of that, I put people in separate rooms, and the reason is I have just found that that leads to uh, more productive results. If they were going to be able to be in the same room together, they wouldn't be here with us in mediation in most cases. But what are your thoughts? Where do you put people together, or do you ever do so?
Well, I do on occasion, more often with attorneys than the parties. I find that backfires if I get the parties and the lawyers all together. Although, and that's the California model, to have separate breakout rooms. But I violate that model if I think that we're not going to settle. I don't just say, well, we've gone for MCLA, we've gone 2 hours and it's clear that there's an impasse. So I want to thank you very much. And there's nothing more that we can do. I never do that. At that point, I might say to the attorneys, how about just we boys, or we boys and girls, go into a separate breakout room without the parties, and let's talk about the disparities and where you guys are at loggerheads. And most of the time, they will agree to do it, sometimes reluctantly, but invariably, at least one or even both of them feel that it's been somewhat productive, more productive than if we had just stopped, because they can really get a better sense of where the lawyer is at. And what happens is, because of the emotion, even on the part of the lawyers, they're less likely to withhold their feelings or their strategies, and they will start talking turkey. They'll say, I'm going to do this and you're going to lose on that. And they may not have done that in their brief, and they wouldn't do it necessarily without that joint meeting after 2 or 2.5 hours. And I think that that's a good thing, because it's a reality check for the lawyers. I have not had a single lawyer complain to me, why did you put me in the room with that person? I agreed, but I was mistaken. You shouldn't have done that. I think communication is everything.
That's really a great approach. And a couple of things that you get out of doing that. Number one, I've had situations where the clients can't stand each other, but the lawyers get along perfectly fine. And sometimes it isn't until you put the lawyers together in a separate room that that dynamic comes out. That's number one. And number two, I'm sure that you have had situations as well where the lawyer needs the mediator to be an ally against their client. And they're not going to be able to do that because they have to be a warrior with their client present. But you put the lawyers together in a room, and one or both of them will say, look, I'm dealing with a maniac. I need your help. How do we get there?
I agree. And by the way, what that is all about is communication. And speaking of communication, I've got a pet peeve. So often, counsel refuse to exchange mediation briefs. And I wrote an article about that several years ago. So when I do my convening package, I include that, and I really promote the fact that they must exchange, or should, I never say must, that they should exchange mediation briefs. and it helps a little bit. And I think that that saves a lot of wasted time in the mediation process. What do you think?
I think that's critical. And most of the time, when a party says, I'm not going to give my brief to the other side, it's because they have a secret that they don't want the other side to know about going into the mediation. And I got to tell you, Bob, I don't know what your experience has been, but I have found there are very few secrets by the time that you get to mediation. And
Well,
yeah,
historic, a few years ago, yes. I think at this point, with early mediations that are court referred, they're not ordered, by the way, they're court referrals. Oftentimes there are secrets, but they can always withhold that stuff. I think it's obvious that exchanging a mediation brief would be helpful, and quite frankly, I think the court should require, just like they do for MSCs, that in a court-referred mediation, they must submit and exchange mediation briefs. And then if they want to withhold something, they can do that, as you can in an MSC. You can do a separate statement for the judge that is confidential. And I don't know why you can't do that all the time in mediation, why it can't be referred, or maybe not ordered, but a part of the referral process, it should be you will exchange briefs.
and the way that I handle that is to try to get a middle path, which is to say, okay, fine, I understand there are certain things you don't want the other side to know going into the mediation. And what I would ask that you do is that you submit a brief to me, which will have black typeset for that which you have shared with the other side, and anything that you want to be a secret, put it in red so that I can see it, but the other side is not going to see it.
That's a good strategy. On the issue of exchanging briefs, there was another point that I wanted to make. I'm losing track of that now, but I just think it's so important and so obvious. And I don't know. Oh, I know what I wanted to say. And that is, when they have not exchanged briefs and we're in mediation, I say, gee, the other side's brief is very interesting, and I think it should be exchanged. Would you be willing to exchange your brief with them if they sent their brief over to you? And about 25% of the time, or even a third of the time, they agree. And that now directs the mediation in a much better direction, because now there is, some reciprocity, which is one of the 7 Cialdini elements of persuasion. They feel like, okay, the guy's being a decent guy or gal, and they start to be more relaxed and more positive about the process. That's my take. So I don't let up. After they don't exchange briefs, I even approach them directly on that point at the mediation, and about a third of the time they do.
One of the questions that we have from the assembled is, do you require that a plaintiff submit a demand in advance of the mediation? And this is very current with me. I've got a civil rights case that I'm going to be mediating on Friday. I've specifically solicited a demand in advance. And, part of the reticence from plaintiffs' lawyers is, well, geez, this figure is going to seem extraordinarily large and harsh and may hurt rather than advance the mediation. Well, my answer to that is, well, then come in with a realistic figure, number one. Number two, there's no harm in asking. And, sometimes what may look to a plaintiff's lawyer as being an unreasonable demand may not be considered an unreasonable demand in the other room. And you're not going to suss that out until you give me a demand in advance. And it certainly saves one heck of a lot of time when we go to mediation, and at least have a starting point. And everybody understands that a starting point, that's no secret. What are your thoughts?
I'm thinking about it right now, actually, and I think it cuts both ways. Sometimes when the demands are outrageous, it does get the defense attorneys ticked off, and then they respond in kind, if not in their briefs, in the negotiations. And other times they appreciate it, And I think probably if they're going to make an outrageous demand, it should be confidential to the mediator so he understands or she understands where that attorney is at, so as not to inflame the other side. And that's an interesting point that I just kind of am considering now. But and again, all of this takes time. You have to talk to the counsel, and time is such a precious thing. None of us seem to have it, and nobody wants to pay for it unless you're, with one of the major leading mediation services, which I will not mention, that charge, $10,000 or more a day. So I think that communicating with the counsel, maybe even in the convening letter, saying if you feel that you're, I invite your demand, but if you want to keep it confidential to me, something along those lines, that might be a good thing.
The other reason that I like a demand is it really depends on the kind of case that we're talking about. If it is an auto versus auto case, the demand's going to consist of loss of wages, medicals. I don't want to say simple situations because obviously personal injury cases can be very involved, but they don't involve a continuing relationship. If I am dealing with a business situation, it may well be that the non-monetary terms will equal or transcend the monetary terms. So I'd like to look ahead of time and see what I can get my creative juices going on before the mediation, because we may be talking about not just X number of thousand or million of dollars. We may be talking about credits on a production. We may be talking about residuals. We may be talking about future royalties. And those just don't come off the top when you're in mediation. It is very helpful to the defense side to take a look at those things in advance so that they can meet with their clients and not get caught flat-footed at the mediation itself.
I think that's a good point, but I think it's critical in the bigger cases that you handle. I seem to handle smaller or more mid-sized cases than you, which is fine. I mean, there's a lot more small and mid-sized cases out there than the large ones. But I think it's tricky, and it requires thought, and probably requires a pre-mediation conference where you get into some of those issues if you're concerned.
We're coming up at the end of an hour. We could spend hours on these things, but I do want to take up one question which we got from David Wong, which is, what do you think of a mediator strategy to put each side in a separate breakout room and wear them both out, telling each side they're wrong on their case and that they should compromise by pointing out the facts and case law against each side? Under what circumstances did that strategy backfire? Listen, I went into mediation because I didn't like that approach. And if you take that approach, frankly, you lose credibility in the broader field of mediation very, very quickly. I tell people that I analyze risk as best I see it, and that I'm going to give them my unbridled opinion. And the reason that I do that is that you have to establish, Bob, the credibility. And there is no credibility where you go into each side and tell them they have a terrible case. That just
Right.
doesn't seem to work. But what are your thoughts?
Yeah, pretty much the same. And that's the old style. Judge Tenor, may he rest in peace, he was kind of that way. He was kind of a force of nature in the 80s and 90s. And I remember being in a mediation where, he just said, this is the most you're going to ever get. And you need to take it or you better try the case. And it didn't feel very good. And it didn't feel like he was trying to make the case resolved. It was basically his rule, and it just didn't feel good. And I agree with that. That's not what mediation is about. And especially in today's angry world, especially today, compared to 25 or 30 years ago, that's not what people need to hear. They need, because even if they agree to it, they end up with a terrible, bitterness. And the process, I think, loses so much of its potential. So I think that that's something that maybe happened in the past frequently, but I don't see it as a good solution today.
Well, and I try to tell people, look, this is not a Scientology meeting where you have only uh, a limited number of bathroom breaks and you can't eat an apple and cheese. I am there to try to make people feel as comfortable as they can under the circumstances. And
Agreed.
the reason is what you don't want to have is a settlement with buyer's remorse on either side.
Right, right. I agree. And that's why kumbaya is a wonderful concept and it's rarely reached, but I think you have to try to seek it. And you don't do that by making people feel defensive at all. I agree.
As I mentioned, we're coming to the end of the hour and we could spend an awful lot of time, but any final thoughts for this session?
Yeah, when you get down to it, mediation in the more sophisticated sense is really an art. You need to get the tools. That's true. You need to understand what's happening, but it's only after you do it and have failures and successes and you start analyzing what worked and what didn't work and what your personality is about. Everybody has different personalities. The mediator, Tony Piazza, who's very famous in the early 2000s and still is, I think, very active, he just lays it out, take it or leave it. And people like him and they respect that. So you have to be true to yourself, but you have to be aware of the temperature in the room. I think it's reading the room is more important than ever now.
And my final thought is kind of akin to yours, which is that mediation is a process. And particularly on the more complex cases, I find that we don't necessarily settle in the first session. It may well be that it takes a couple of follow-up phone calls before the parties have absorbed all the information that they need in order to settle the case.
I agree. And I'm going to hopefully stop talking after this, but that leads me to another thought. And that is historically, when I was doing mediations after my time with Kravitz, voluntary stuff with the Superior Court and some pay panel stuff, if I felt there was an impasse, I would just say, we can't go any further. I don't do that now. I say, gee, this has been great. I'm a salesman. We've really learned a lot, but we've also learned all sorts of things that we don't know. So why don't we continue this? We've gone 2 hours and it's supposed to be 3, or we've gone, 4 hours and or 3 hours and it's supposed to be 4. I'll give you another hour and a half. I give them an extra half hour. Go do some discovery, do this. Let's have 1 or 2 status conferences maybe in between the time that we reconvene, and then let's reconvene. And they like that. They appreciate that. So I think you need to keep working at it. And, the idea of stopping the mediation because the parties are too far apart is not the solution in today's world.
And it is amazing how after a little reflection, the parties can come together after that first session.
Right.
Speaking of which, we've reached the end of our time. I want to thank everybody who has joined us. I'm sorry that we didn't get to all of the questions. It may be that it's worthwhile for us to do a part 2 on this. I've really enjoyed this, and thank you for sharing that first cup of coffee with Bob and me.
Yeah, have a good day, everybody, and wherever you are. And I hope this gave you some insight into the way we think, and maybe you'll get some ideas from it.
Bye now.